welcome to our latest episode of the Adams and Adams Africa IP series. We continue our focus on the top filing destinations in Africa and showcasing our people in those jurisdictions who form an integral part of the Adams and Adams Africa network. Today, we turn our attention to Kenya, with one of the largest economies in Africa and one of the premier trademark and patent filing destinations in Africa. To tell us more about IP practice in Kenya, I am joined by John Sieki from our associate office in Kenya. Welcome, John.
Thank you, Menzi. Happy to be here.
John, just to kick us off, could you tell us how long you've worked as the Adams and Adams local partner in Kenya and how this journey has been for you so far?
Thank you, Menzi. I've been working with the Adams and Adams team as a local partner in Kenya since 2012 and formalized our relationship in 2014. So it's been close to 10 years of close working relationship. It's been a great journey, exciting. The work has grown tenfold over this period. We've been involved in excellent matters in the High Court, worked on a lot of oppositions, cancellation matters, and filed a lot of trademarks for a lot of great brands from around the world, working with the Adams and Adams lawyers who handle the trademark filing work. I would say that my team and I have really enjoyed the time we've been working with Adams and Adams on these matters for their clients.
Thank you, John. The enjoyment has definitely been mutual. And turning now to the registry, would you give us an update as to how things are progressing at the registry?
Yes, thank you, Menzi. The registry has struggled quite a bit over the past 12 months with the COVID pandemic. There has been a slowdown on work because going on at Kipi, because a lot of the times the office was closed due to the lockdowns in Kenya. But now everything has picked up again and there's a lot of filing happening. I would say that before the pandemic began, the Kipi office had really ramped up in terms of staffing. Examination of marks was going on quite well. Oppositions and cancellations were proceeding very well. But now, during the pandemic period, there was quite a bit of slowdown, and there was a lot of requirements for searches to be done officially rather than filing and conducting searches personally, which then has slowed down the way in which we've been working at Kipi. But we hope that everything will clear up as time goes by, because the office is being reopened at Kipi in terms of access, and we believe that efficiencies will recover at Kipi.
Excellent, thank you, John. And carrying on with the registry, in terms of the digitization of the records, can you give us an update on that as well?
Yes, yeah. So the digitization of records at Kipi has been going on quite well. Close to 80% of Kenya's patents and trademark matters have been digitized. You're talking about 5,000 patent applications and close to 90,000 trademarks have been digitized. This means that in due course, they will complete the process, and then the next phase will start, which is access to the platform to agents and to brand owners to conduct searches online and also to file applications online, which is something we're really looking forward to.
Thank you, John. That's actually very good progress on the part of Kipi, and we hope that they'll keep it up. And then turning now to our final question, which is really relating to one of the inquiries that we receive on a very regular basis, is that relating to the international registrations under the YPOS Madrid system. I just want to find out from your experience how this is going in Kenya and how the registry is handling it, and whether the system can be relied upon without any risk to brand owners going forward.
Yes, thanks, Menzi, for that. That's a very good question. I think Kenya has been party to Madrid for a while, but we are still going through a lot of struggles in terms of how the system works. The reason for this is because at Kipi, we only have one examiner that handles Madrid applications. And because of that, the turnaround in terms of examining applications is quite slow. You need to bear in mind the fact that under the Madrid rules, there's a very strict timeline within which marks need to be reviewed and examined and reported back to WIPO. This obviously does not happen in good time in a number of instances in Kenya. And the implication there is quite dire for an applicant who has used the Madrid system, who then receives notification from Madrid that he has received registration in Kenya, yet there is a likelihood that that registration is actually incomplete. The other issue that arises is that oppositions and official actions that are raised by examiners and or oppositions filed by third parties against these Madrid applications are not notified in good time to WIPO. And because of that, WIPO would again notify applicant that their mark has been registered in Kenya under the Madrid system, yet that mark has not yet been registered to completion. And what would happen then is that when the applicant seeks to enforce that mark, they would be surprised by a direct cancellation being filed against that mark, because that mark should not have been on the register in the first place. So there are a couple of hiccups and inefficiencies, I think, with the technology and transmission of documentation and information between WIPO and the Kenya KIPI office. And that reason is really because the system needs to be improved and we don't have enough resources in terms of reviewing these marks. And then that essentially means that the trademarks that you will get registered to the Madrid system might have a lot of errors and hiccups that would be difficult when looking at enforcement. So I would always advise, if necessary, if as a first port of call, filing a national application into Kenya to get comfort that you have a valid registration in the Kenyan market, which can be enforced.
Yes, thank you, John. That was going to be my follow-up question, to say, would it be advisable then for someone to proceed by way of national registration at this stage?
Correct. Menzi, I cannot emphasize it more that it would be very advisable to use a national direct filing into the market as your mode of protection, rather than relying on Madrid at this point in time. Until these hiccups are resolved, it is risky to rely solely on a Madrid filing as a system of protection for this market. I think maybe this will be resolved in due course, but for now, national filing is best. I need to also add that when you have to enforce by going through to the High Court to enforce a trademark application in Kenya, it is easier to rely on a locally filed national application, because there's a clear process as to how one can get a certificate validated for use in legal proceedings. As for a Madrid application, the form required to create or to use the Madrid application as a mark for use in the High Court has not yet been crystallized by the KIPI office. So that is not very clear, and the chances are that there would be questions as to the legality of an infringement suit filed before the High Court of Kenya, relying on a Madrid application, because of that issue of having a certificate for use in legal proceedings, which is only prescribed for locally filed applications.
No, thank you very much, John, for those insights. This will definitely be something that will need to be heeded by our clients and anyone wanting to file in Kenya going forward. John, thank you for your time that you've given us, for sharing your insights on Kenya. And at this stage, we'd come to the end of our recording, and would like to thank you for your time, and to also thank the listeners for the time that they've given us in listening to this series.
Thank you, Menzi.
Thank you, John.